Okay, good morning, everyone. This is the Court of Appeal for Bermuda sitting on the 24th of June, 2021. We are sitting for the matter Civil Appeal number 5 of 2021, Oswin Pereira against the Commissioner of Police and the Public Service Commission. These proceedings are taken before my Lord President, Sir Christopher Clark, and Justices of Appeal Kay and Bell. My Lord President.
Good morning, everybody. I'm sorry there's been a slight delay, which has been attributable to internet problems, as usual. But otherwise, we're ready to start. The screening, I think it's for you.
Yes. Morning, President and my lords.
Good morning.
May it please the court.
Could I just clarify, Ms. Greening, we have Mr. Taylor for the Commissioner. Does Mr. Horseman appear in this appeal? No.
No, I don't believe that he does. No, he hasn't participated in this appeal.
Right. It was rather strange that the first instance judgment referred to him, but so he did appear at first before Justice Sir Williams.
Well, he appeared briefly.
All right.
That's rather cryptic.
Well, it does form part of the grounds of my appeal. He appeared very, very briefly and then excused himself because he didn't, although he did submit written submissions, he didn't really go through them, having decided that he may be at risk of bootstrapping his judgment. But he did appear. And he spoke for about 9 minutes and then he excused himself from the rest of the proceedings.
Right.
Yes, my lords.
Okay.
Shall I begin?
Yes, please.
Yes, this is an appeal. Well, this is a variety of things. This is an application to renew or an appeal against the ruling of a single judge in an interlocutory matter pursuant to Order 2, Rule 38.2 of the Rules of the Court of Appeal in relation to the poor person's application that was initially made. What ties in with that is the respondent's application for security for costs. It was decided or agreed by all that because the test is a reasonable probability of success, that the appeal itself could be rolled into this application and everything heard all at once. And I will proceed on that basis as I did when I filed my written submissions. I will take the court through a very brief chronology so that we're all on the same page as to why we're here today. The appellant was dismissed from the Bermuda Police Service in January 2020 following a misconduct panel, following a finding of gross misconduct, namely that he had assaulted a member of the public, Tulunde Grant, and that he had so that's one, that he had switched off his body camera, 2, and that he had given an implausible account to the panel at trial. The appellant appealed to the Public Service Commission as he is entitled to do, and in August 2020, the finding of assault, which was made by the misconduct panel, was overturned by the PSC on the ground that it was unreasonable to make that finding. But the finding that he had switched off his body cam and given an implausible account was held not to be unreasonable. As a result of this change, his dismissal was varied to one of a final written warning, having previously been dismissed without notice. The respondent judicially reviewed that decision of the PSC, and in February 2021, earlier this year, the PSC's decision was overturned by the Supreme Court on the basis that they had erred in law. This is, amongst other things, an appeal of that decision of the Supreme Court.
Yes. Could you just help me on one thing?
Hope I can.
If we could look at it's most convenient for me found in the judgment. If you go to the record of appeal, page 32, the learned judge sets out the decision, or a large portion of the decision,
Yes.
of the Public Service Commission. And at the bottom of the page, at paragraph 59, she says, in terms of the harm caused, there was no physical harm found to be suffered by Mr. Grant at the hands of the appellant by reference to any unjustifiable assault.
Yes.
There was no evidence of the physical injury, any physical injury attributable to the alleged assault. Now, it's not entirely clear to me whether they found that there was no assault or that there was no unjustifiable assault. Slightly, well, different things.
My understanding, my lords, is that there was the finding of assault altogether was overturned because there's a part in the decision of the Public Service Commission where it says that all of the members of the PSC, the panel, unanimously decided, having looked at the body cam, the recording, the body cam footage, that no assault had taken place.
Right.
But where do we see that, Mr.
Yes, I'll just.
I'm looking at 62 of the PSC decision, which says, having considered all the factors in this case, and in light of finding that no evidence to support the panel's finding that the appellant unlawfully assaulted Mr. Grant, the PSC finds that dismissing the appellant without notice was unreasonable. So they seem to have conflated the finding in relation to assault and the appropriate disciplinary sanction.
Yes. Well, I will just start by saying that this portion of the PSC decision was unchallenged by the respondent. But in any event, to answer your question, paragraph 44 of the decision of the PSC, which is headed up, was the finding that the appellant unjustifiably assaulted Mr. Grant unreasonable? And this is the PSC's going through and explaining why they have reversed the finding of the panel. 44, the PSC also reviewed the body camera video evidence in depth. A special hearing was convened to allow for the video to be shown frame by frame, facilitated by Detective Constable Nigel Richardson. The PSC were unanimous in its finding that the body camera recording did not show Mr. Grant being struck twice in the head as found by the MPP, the misconduct panel.
Yeah.
Indeed, as mentioned above, PC McNabb, he was one of the witnesses for the appropriate authority to talk about the body camera footage, concurred that the recording did not show the appellant being struck twice in the head. Mr. Dunch,
Right.
chair of the MPP, indicated during the hearing that despite viewing the video recording for several hours, the MPP did not see the appellant being struck by the ASP baton. 45. There was no medical evidence adduced that, but there were some pictures of Mr. Grant exhibited in the record which do not evidence any injury to the left side of his face. The PSC also notes the visit summary of the KEMH, that's a hospital here, specifies the presenting complaint as taser injuries to Mr. Grant's abdomen and road traffic collision. 46. Given the MPP ruled it would not take into account the veracity of Mr. Grant's statement, the MPP ruled that they would only admit Mr. Grant's statement because he had subsequently died for the purposes of background and setting the context. Given the MPP ruled it would not take into account the veracity of Mr. Grant's statement, the only evidence had available to it to make a determination as to whether the appellant struck Mr. Grant twice in the head was the recording itself and the appellant's evidence. And the appellant denied it. Indeed, as referenced above, Mr. Dunch, the chair, noted that after reviewing the recording for a substantial period of time, the MPP did not see the appellant striking Mr. Grant. PC McNabb also testified the recording did not definitely show the Ash Patten come into contact with Mr. Grant. 47. The PSC, having carefully considered the body camera evidence, finds that the MPP's conclusion that the appellant unjustifiably assaulted Mr. Grant by striking him twice in the head was unreasonable and reverses that finding.
Right.
So
there we have it.
And then there are many countless references, and I can go through them all the way through the decision, and more towards the end when they're narrowing down what to do, to suggest that the finding of assault in its totality had been reversed. I hope that answers your question, Mr. President.
It does. It does.
So I don't think that there is much dispute. I'm trying to narrow the issues down as much as possible. I don't think there's much dispute between the parties or the court in relation to whether the respondent was able to judicially review the PSC's decision. The parties, I think, are in agreement that notwithstanding the constitutional safeguard of Section 84(7) of the Bermuda Constitution Order and Section 28(5) of the Police Conduct Orders that states decisions of the PSC are final, nonetheless, decisions of the PSC are judicially reviewable on the grounds that the decision was either perverse or an obvious error of law. And I agree with that. The dispute here is whether the PSC erred in law, which we say they did not. And that is, in a nutshell, what my ground one is about. We say that the PSC did what was proper and what was legitimately open for it to do. The court cannot intervene just because they think the decision that the PSC reached in terms of sanction was less harsh than many would have expected. It is not for this court, or it is not for the Supreme Court to substitute its decision for a decision of the PSC which was properly seized of the case, unless the PSC reached a conclusion which was so far outside the range of decisions legitimately open to it as to render it unlawful. And that is the nub of this appeal.
And isn't it the case, Ms. Greening, that the first instance judge was very much alive to the need for her to find that the PSC had erred in that way?
She purported to be, and I will go through the.
Right.
I will go through that judgment, and with respect to her ladyship, I say that she erred, and she misapplied the leading cases of Salter and Williams. She didn't take into account the various different things that the PSC did take into account carefully and considered, which they were entitled to do, and she intervened. She intervened in a decision that she was not entitled to do.
Can we, just before we start upon that exercise, help me on this? We are concerned with a decision of the misconduct panel, which was then appealed to the Public Service Commission,
Yes.
which was then judicially reviewed by the court.
Yes.
Now, can we just take it in the proverbial stages? When the Public Service Commission had to consider the decision of the misconduct panel,
Yes.
were they only entitled to interfere and change the decision of the misconduct panel if either they perceived some clear error of law or the decision of the misconduct panel was Wednesbury unreasonable?
Yes, the different. ways in which the PSC can interfere with an MPP decision are laid out in section 28 of the police conduct orders, which are included in my bundle.
Miss Greening, can I just apprise you of a technical difficulty that I, for one, have? I mean, we'll just have to work around it. Because there's no internet connection this morning in the Magistrates' Court where I am sitting, they have not been able to find an internet connection. They have produced a laptop for me, which they've hardwired so that I can participate in this call, but it means I cannot access the cloud. So I happen to have hard copies of Salter, but and I've got hard copies of the record and in volumes 1 and 2, but I'm not able to access the cloud. So
I can read out the.
Mr. Coelho has in other cases shown us that he can put it up on the screen if you give him the appropriate references.
Yes, I emailed Mr. Coelho to ask if the shared folder had been disseminated or sent out to us. I didn't receive anything, or if I didn't receive it, it's maybe my fault in that I should have been able to access it somehow. I'm going off hard copies that I have, but I can certainly refer to them by tab number.
Yeah. What are you taking the court to now, Ms. Greening?
First of all, I'll take them to tab 1 of my my bundle, which is the Public Service Commission Regulations 2001.
Okay, just give me a minute.
Mr. Coelho, I'm lost as to which bundle we're now talking about. I have no bundle with tabs.
That was sent on the.
Are you referring to the record of appeal?
If it helps on this particular provision, it's set out in the judgment below at page 39 of the record.
I think that does help.
(38 and 39).
Yeah.
38 and 39?
Yes, and I've got a hard copy of that, Mr. Coelho.
Oh, okay.
Yes. Yeah.
At paragraph well, if we're looking at the Supreme Court judgment, at paragraph 31, order 38 subsection 2, as read with order 38 subsection 4b, permits a police officer whose case was decided at a misconduct hearing to appeal to the Public Service Commission only on the following grounds. Subsection 2, the only grounds of appeal under this order are that A, the finding or disciplinary action imposed was unreasonable. And I will go back to answer the President's question about whether that's Wednesbury unreasonable or some other type of unreasonableness. B, there is evidence that could not reasonably have been considered at the misconduct proceeding, which could have materially affected the finding or the decision on disciplinary action, and that doesn't apply in this case. Or there was a serious breach of the procedures set out in these orders or other unfairness, which could have materially affected the finding or decision on disciplinary action. And the PSC considers, in this case, whether there was unfairness, and they found that there was in relation to a finding of assault, and whether or not the finding or disciplinary action imposed was unreasonable, and the PSC found that it was unreasonable to dismiss the appellant and varied that finding, varied that sanction. They were able to vary that sanction under the Public Service Commission Regulations 2001, which helpfully follows in the Supreme Court judgment at paragraph 32. Part 6 of the PSC regulations applies to disciplinary procedures and appeals. Section 28 of appeals to the PSC provides appeal to the Commission. 28.1, where A, the disciplinary powers vested in the governor by Section 82 of the Constitution have been delegated to an empowered person under Public Service Delegation of Powers Regulations 2001. B, a disciplinary award of a gross misconduct penalty has been made by the empowered person.
And that would be the panel.
Yeah. C, in the case of a member of the Bermuda Police Service who has received a disciplinary outcome of dismissal, that's my client, or reduction in rank following a stage 3 meeting under the Police Performance Orders 2016, or any disciplinary outcome following a misconduct hearing under the Police Conduct Orders 2016, the member may appeal to the Commission. The grounds of appeal for a member of the Bermuda Police Service are that, and then 1, 2, 3 mimic the police conduct orders. The finding or disciplinary action imposed was unreasonable, or 2, there is evidence that could not reasonably have considered at the original hearing which could have materially affected the finding or decision.
Which does not apply.
Which does not apply. Or 3, there was a breach of the procedures set out in the conduct orders or the police performance orders or other unfairness, and the PSC attached themselves to this other unfairness, which could have materially affected the finding or decision on disciplinary action. Any officer who is aggrieved by the disciplinary award may, within 14 days receiving notice of the disciplinary award, appeal to the Commission by giving notice in writing to the Commission and to the person who made the disciplinary award. And then I'll just jump down to subsection 4, which says the Commission may, A, affirm, reverse, or vary any disciplinary penalty imposed by the disciplinary award, or remit the matter for determination on rehearing by the empowered person with or without any observations the Commission thinks fit to make. And while we're here, I'll just read out subsection 5. The decision of the Commission on an appeal shall be final. And I've already addressed that point, which is that notwithstanding that and the provision in the Constitution order about the PSC being the final authority, it is accepted that decisions of the PSC are judicially reviewable if it can be shown that the decision was perverse or an obvious error of law. We say that they, which we say it cannot. So to go back to the question the President was asking about whether or not that unreasonableness as laid out in statute is a Wensbury unreasonableness, I would answer in the negative and rely on the case that was submitted at late notice to the court of Ruckin, a 2017 case, which is remarkably similar in many ways to this case before the court this morning. In that case,
where do we find that?
That was a case that was submitted electronically to the Court of Appeal, to your clerk, and to the respondents' attorneys yesterday. I apologize for the late notice, but I thought that it was a very useful case for everyone to read through, particularly given that it came after the Salter and Williams cases and refers to them in quite a lot of detail. And also the circumstances of this case are quite similar, particularly in that the chronology of this case is almost identical to the, hello?
We're here. This is the case that you've just referred us to.
Yes, and particularly in that the chronology is almost identical to the case at bar, in that the police constable was sent to the misconduct panel in the UK. He appealed that decision of dismissal to the Police Appeals Tribunal, which is the equivalent in the UK to the police to the Public Service Commission here. The Police Appeals Tribunal varied the sanction from one of dismissal to one of a final written warning, The chief constable judicially reviewed that decision, and this is the judgment that says that the police appeals tribunal did what was proper and what they were entitled to do, and that although it may be criticized in that the decision that they reached was possibly less harsh than many would have expected, it is not for this court, as in the Judicial Review Court, to substitute its decision for the decision of the appeals tribunal, which was properly seized of the case, unless they had reached a conclusion which was so far outside the range of decisions legitimately open to it as to render it unlawful. In this case, Ruckin, the constable had been assaulted by the woman he was having an affair with's husband very badly and received facial injuries. He was then asked by various members or various colleagues and members of the police service over in the UK what had happened to him, and he lied to them. And it was not just a one-off lie, it was a continuing lie, which he built upon every time someone asked him more about it. He told them that he had fallen off his bicycle, and then he showed them photographs of his damaged bicycle. And then he continued to lie to various different colleagues about what had happened, because he didn't want to tell them the truth that he had been assaulted by his married girlfriend's husband.
Ms. Greening, I mean, it may come out when we look at the judgment, but there's a difference obviously between lying in a social setting or lying in relation to some official inquiry. Which did it take?
Yes, well, there's quite a lot about the public-private dichotomy in this case, and it was decided that notwithstanding the end result, which was one of a final written warning, that because he was a very senior member of the police service, and because he had lied to colleagues on a continuing basis, it was not a private, it was not considered to be an issue of lying in a private capacity. He was lying to colleagues in the course of his employment, and his lawyer tried to argue that he should be protected by Article 8, a right to be protected, his private life to be protected, and that didn't go anywhere. So I hear what Justice Bell is saying, that it may be that there's a distinction between.
I wasn't saying anything, Miss Greening. I was just making inquiry.
Yes, but inquiry.
Not coming from a position.
Okay, well, there is quite a lot, and I do intend to go through this Ruckin case in some detail, so it may come out in the various sections that I intend to read out. To go back before I forget to the President's question about the test of unreasonableness and whether it is a Wensbury test, and I said that I didn't agree that it was, and I intended to rely on this Ruckin case. If Mr. Coelho, if we could go down to paragraph 52 of this case, I intend to read out the first few paragraphs under the heading case law. Yes, there. I have been referred at length to two cases, the first of which is RCC Durham versus PAT Cooper 2012 EWHC 7233 admin ACD 20. This was a decision of the Divisional Court. The second case, to which extensive references have been made, is R. Williams versus PAT 2016 EWHC 2708 admin, a case that Justice Kay will be very familiar with. I have also been referred fleetingly to other cases. Paragraph 53. I do not intend to quote from either Cooper or Williams at more length than I think is strictly necessary. Mr. Yeo, he's the lawyer for the appellant, I think, in his skeleton argument, cites extensively from paragraphs 5, 6, and 7 of the judgment of Lord Justice Moses in Cooper. His purpose in doing so is to explain how the provision of Rule 4.4 of the 2012 rules referred to above are to be construed, and that is the equivalent to the Police Conduct Orders and Public Service Commission regulations in relation to the test of unreasonableness. I propose simply to confine myself to the principles that can be gleaned from those citations. Capital A, when considering whether a finding by a panel is unreasonable, the Police Appeals Tribunal is not required to find it Wednesbury unreasonable as a prerequisite for overturning the decision of the panel. And that is what I rely on to answer the question as to whether or not it's Wednesbury unreasonable. B, the PAT is not entitled to substitute its own view for that of the panel, underline, unless and until it has already reached the view, for example, that the findings made, I think that should say made by the panel was unreasonable, or that there was another valid basis for appeal as provided by 4.4b or 4.4c of the rules. The Police Appeals Tribunal is entitled to substitute its own view for that of the panel once it has concluded either that the approach the panel took was unreasonable, which it did in this case, or the appeal from the panel's decision is justified under grounds 4.4b or 4.4c, which it did in this case, or the equivalent statutory.
I'm not sure where you are, Ms. Green. Where are you reading from now?
If you can look on the screen, capital C, I just read that bit.
Right, thank you.
Capital D, in other words, Rule 4.4 provides a gateway for an appeal. If the appellant gets through the gateway, because the Police Appeals Tribunal, or PSC here, find that the decision of the panel was, for example, unreasonable or unfair, in this case both, then it is open to the Police Appeals Tribunal to substitute its own views for those of the panel. Once the gateway is negotiated, which it was by the PSC, and in my submission clearly in its 22-page judgment, the Police Appeals Tribunal can deal with this matter on a clean slate basis and can make an order dealing with the appellant in any way in which he could have been dealt with by the panel whose decision is appealed. Paragraph 54. Mr. Apthorpe took me to a number of passages in Williams, predominantly on the basis that it codified principles enunciated in previous cases, but it is also right to say that the issues in Williams bear a good deal of similarity to the issues with which I am concerned. 55. That case too concerned a police officer who had attained high rank and who was very highly regarded, as is the case here. Mr. Williams was alleged before a misconduct panel to have been guilty of gross misconduct. The panel concluded that he had indeed been guilty of gross misconduct and concluded that the appropriate sanction was dismissal without notice. The difference in the Williams case is that the Police Appeals Tribunal to whom Mr. Williams appealed took the view that the findings of the panel and sanction it imposed were not unreasonable and so dismissed the appeal. That is in distinction to the instant case where the Police Appeals Tribunal regarded the decision of the panel to have been unfair, unreasonable. So in that case, our case here today is similar to the Ruckin case and distinguished from the Williams case. The judicial review in Williams centered on Mr. Williams' contention that the decision as to sanction made by the panel and the Police Appeals Tribunal was unlawful. Williams is useful because of its analysis of earlier cases principally dealing with the question of sanction. The starting point is perhaps Bolton versus the Law Society 1994 2 all ER 486, and that's a case that the judge in the Supreme Court in the judicial review quotes extensively and relies heavily on because Salter also relies on it. That is a case relating to the conduct of a solicitor, but it is of general application. The principle that emerged from that case expressed by the decision of Sir Thomas Bingham is that where a person in an occupation in which the trust and confidence of the public is reposed is guilty of dishonesty, then it is almost invariably the case, no matter how strong the mitigation, that a person's career will be ended by his or her disciplinary body. This is because the reputation of the profession is more important than the fortunes of any individual member. Membership of a profession brings many benefits, but that is part of the price. That principle was specifically approved in the Law Society versus Salisbury 2009 1 WLR 1286 at paragraphs 3 and 37, where Lord Justice Jackson stated that there existed only a very small residual category, and that's the same phrase that is used in Salter, where ending a professional person's career for dishonesty was not appropriate. In that case, however, it was recognized that in applying Bolton principles, account had to be taken of the rights of the person under the European Convention of Human Rights. The effect of Bolton and Salisbury was further analyzed in Solicitors Regulation Authority versus Dennison 2011 EWHC 291 at paragraph 16. It is not, in my view, necessary to cite that in detail. It sets out the purpose for the imposition of sanctions by professional bodies and draws attention to the fact that, albeit there may be a punitive element in such sanctions, that is not the primary purpose, and that accordingly personal mitigation is likely to be of less effect. And that's the issue of personal mitigation will come up later. Nevertheless, regard must be had to the rights of the person under ECHR. So all the cases agree with that. Perhaps for the purpose of this application, it is wise to have regard to paragraph 16.7 of Dennison, where it is said, the power of the High Court to interfere with a decision of the tribunal on sanctions is not limited to cases where a very strong case is shown. The court will intervene where there has been an error of law or when a sentencing decision was clearly inappropriate. In the case of Chief Constable of Dorset versus Police Appeals Tribunal and another, 2011 EWHC 3366 is a case concerning a police officer. It is generally known as the Salter case. Justice Burnett, as he then was, concluded at paragraph 22 that the correct approach to the question of sanction on a finding of serious impropriety by a police officer in the course of his duty is reflected in the principles articulated in Bolton and Salisbury. The reasons which underpin the strict approach applied to solicitors and barristers apply with equal force to police officers. Honesty and integrity in the conduct of police officers in any investigation are fundamental to the proper workings of the criminal justice system. The learned judge made it clear that the most important purpose of the imposition of sanctions, particularly in cases involving dishonesty or impropriety in connection with an investigation, is to maintain public confidence in the police service and to maintain its collective reputation. He went on to say, cases of proven dishonesty and lack of integrity in an operational environment are the most serious breaches of the code of conduct. In such cases, the sanction of dismissal or requirement to resign would, to use the language of Sir Thomas Bingham in Bolton, almost invariably be appropriate, but there exists a very small residual category where a lesser sanction may be available, which was made in the appeals tribunal, in this case, Ruckin, and upheld by the court. In the Court of Appeal 2012 EWCA Civ 04, the court upheld the conclusion reached by the judge below that, in accordance with Bolton, mitigation is unlikely to assist the police officer from avoiding dismissal. But Lord Justice Maurice Kay made the point that, while I would certainly accept that not every untruth or half-truth told by police officer, however trivial or whatever the circumstances, would necessarily constitute misconduct justifying dismissal, the misconduct found by the panel constituted deliberate dishonesty in an operational context. Williams is also useful for reminding the court, a court hearing a judicial review from the decision of a police appeals tribunal, what the obligation of the court is. As Justice Holyrood puts it at paragraph 62, it is common ground that in this claim for judicial review, I must, in effect, carry out a review of a review and must therefore consider not just the decision of the police appeals tribunal, but also the decision of the panel. The question for the police appeals tribunal was not what sanction they would have imposed had they formed the panel, but whether the panel's decision as to outcome was unreasonable. The question for me is whether the decision of the Police Appeals Tribunal was vitiated by error of law or was so far outside the range of decisions legitimately open to the Police Appeals Tribunal as to be unlawful. And that is where we're at in my.
Just pausing there. Can we just pause for a moment? Can you bring the?
Well, I'm going to pause there, yes. Anyway.
Guys, sorry. Can we go back to where we were looking before? Can we go down? Bring the thing down. Down.
You give me a paragraph
Yes.
number?
62. 62. Yes.
That's it.
Mr. Justice Holroyd, as he then was, says in the second line of the quote, the question for the Appeal Tribunal was not what sanction they would have imposed had they formed the panel, but whether the panel's decision as to outcome was unreasonable. And I suppose you would say, well, that's the first question for the Appeal Tribunal to decide. They've got to decide, firstly, whether the panel's decision was unreasonable. And if they decide that it was unreasonable, then it is for them to decide what sanction they would have imposed had they formed the panel.
Correct. And and after reading that and ending at paragraph 62, I was going to take this court through the decision of the Public Service Commission to show,
Right.
in my respectful submission, that that is just what they did.
Right.
So the PSC decision, they look very carefully, and as I have already stated, this is a 22-page judgment, and in distinction to the Ruckin case, where there are various references to the decision of the Police Appeals Tribunal not being particularly detailed or in full, this one in my submission is full and detailed, and as a result cannot be criticized by the a higher court in that regard. I will start at paragraph 24, because the first.
Where are we looking at? Are we looking at the record of appeal somewhere?
I've got it at 297 of the record.
I've got it at 229. For some extraordinary reason, the decision of the Public Service Commission appears in, I think, something like 6 different versions.
Yeah.
Yes.
I can't
Because
imagine why.
everybody files an affidavit and refers to it, I think is the answer.
Very unhelpful for present purposes. Okay. Some degree of pruning would have been desirable, but never mind. Anyway, which paragraph of it are we looking at?
I'll start at paragraph 24, which is in reply to the appeal grounds that deal with.
Yes.
I filed 4 grounds of appeal to the Public Service Commission in relation to the assault. And at paragraph 24, the PSC replied to that in their decision. Sadly, Mr. Grant, he's the member of the public, died in an unrelated road traffic accident prior to the disciplinary proceedings. It was clearly open to the MPP to admit the statement, as the maker of the statement is now deceased. In order to address any unfairness that might arise, so they're using the word unfairness, the MPP stated it was only admitting the statement for the limited purposes of setting the background and context of the complaint. The PSC can find no fault in the MPP adopting that course and admitting his statement for that limited purpose. Mr. Grant, however, testified at the appellant's criminal trial in Magistrates Court, which was prior to the misconduct panel trial, and would have been subjected to he was subjected to cross-examination during those criminal proceedings. Counsel for the appellant and PC Bowden, who was my client's co-accused at that time, sought to admit the evidence given during the Magistrates Court trial. The MPP declined to review the recording or transcript as offered by Mr. Doughty, who was representing PC Bowden, of the criminal trial. The PSC is of the view that the appellant was denied the opportunity to put before the MPP evidence that may have assisted him in his defense of the charges. At the core of the disciplinary charges was the allegation that the appellant had struck Mr. Grant twice in the head with his asp. Mr. Grant, in his witness statement dated the 13th of September 17, made several allegations against the appellant for which there appears little or no supporting evidence. And remember, because the MPP had only admitted Mr. Grant's statement for the limited purposes of context and background, these allegations did not form or should not have formed part of the evidence at the MPP trial. 1, the appellant hit Mr. Grant multiple times in the face. 2, while on the ground, the appellant kicked Mr. Grant in the face. While on the ground, the appellant beat Mr. Grant in his leg. When on his knees, the appellant hit him in the head. When on his feet, the appellant gripped the handcuffs and pulled Mr. Grant down twice. When they got to the roadside, the appellant again pulled Mr. Grant down to the ground by the handcuffs. When Mr. Grant looked at him, the appellant hit Mr. Grant on the left side of the face with his helmet. It is noted that the appropriate authority adduced no medical evidence at the hearing before the MPP. It should also be noted that Mr. Grant did not make any complaint to the police until 2 weeks before his own trial for possession of a knife and road traffic offences. He did not make the complaint at the time, and for some 18 months right before he himself had to plead guilty to his own criminal charges. In the opinion of the Public Service Commission, there was no independent evidence confirming any of the allegations listed above. The King Edward VII Memorial Hospital visit summary exhibited in the appeal record specifies the presenting complaint as an abdominal injury related to being tased by the police and a road traffic collision. It is telling that there was no evidence of a complaint of an assault made by Mr. Grant on the 13th of May, 2017. Presumably, Mr. Grant would have been challenged in cross-examination on these, which he was, and other matters such as the late complaint, which seemed to have arisen after Mr. Grant's criminal defense attorney had obtained a copy of the body camera video in disclosure in the criminal proceedings. Had the MPP reviewed the recording of the criminal trial, which was offered to them and they declined, the MPP may well have formed a different view as to whether or not the appellant actually intentionally struck Mr. Grant with his asp baton. Given the appellant was fighting for his professional life, the PSC is of the opinion that the appellant should not have been denied the opportunity to put the cross-examination of Mr. Grant into evidence if he had so wanted. In the absence of Mr. Grant being present for the hearing, there could be no better evidence for the MPP to consider whether Mr. Grant's complaint was credible. And I just pause here to say, in case it's not clear, that the appellant was acquitted of the criminal charge of assault. The PSC finds the refusal of the MPP to admit and consider the evidence was unfair to the appellant and allows this ground of appeal. The question of what flows from accepting this ground of appeal is dealt with in the section below when considering whether the finding of an unjustifiable assault by the MPP was unreasonable or not. So I read that out and I'll continue to read out.
That's all to do with the assault, not with the dishonesty, which is the crux of the case now.
Yes, I read that out to because I'm at pains to point out that the PSC considered if we go back to paragraph 62 of the Ruckin case, which says that the job of the Police Appeals Tribunal in the UK, the PSC here, is to look closely at the MPP's decision when deciding whether or not it was unreasonable when it came to its finding or decision in terms of sanction. And I read this out to show that the PSC here has gone very carefully through every single aspect of the misconduct panel's trial and considered all of it in coming to their conclusions. But yes, my lord, I agree. This is in relation to the assault, but which
is not really an issue before us, though, is it? Because
Well, only in so much in that the gravamen of this of the allegations was that he was assaulted. The assault goes away, and so all that is left now is that the PSC did not find that the appellant's implausible account, or the MPP's finding that the appellant made an implausible account in relation to his body cam being off, was unreasonable. Did not find it unreasonable.
well, were the two things left? What was the first? What the appellant was alleged to have said to PC Bowden, and then there was the implausible account.
Yes, so there are two things. There's first of all the evidence that he said cameras off, or he was heard to say cameras off on
Yes.
on the body cam, and then the second part was that he gave an implausible account.
Well, wait, is that quite right? I had thought the two things which remain are, firstly, he turned the camera off so that it couldn't record anything. And that's what he did when he said cameras off.
Yes.
He then gave the implausible account that when he said cameras off, he wanted to ensure that PC Bowden's camera was on.
Well, the account that the appellant gave to the court, to the panel, was that he wanted to ensure that Bowden's camera was on.
Yes.
That
Yes,
was not accepted.
That's the point.
That was considered implausible. Or that was
Yes, because he had turned his camera off, and the last thing he wanted and that's why he said cameras off, because that's what he'd done. And the last thing in the world that he wanted was for Bowden to turn his camera on.
But the reason why, other than to show that the PSC did a good job at explaining their decision-making process, the reason why I raised the issue of the assault is that if there was no assault, and that was really the complaint made, and everything else flowed from that, then what is it that anyone is saying my client is hiding?
Well, isn't what's being said against your client is that to intentionally turn off his body camera is a dishonest act, and then to put forward an implausible account of what he was actually doing is similarly a dishonest act.
Yes, and the PSC go through that very carefully. Once they've dealt with the issue of assault and they've reversed that finding, they then go, and I can go straight to it at paragraph 48, they then go on to consider the whole issue of this body camera business very carefully. And they, in the context of there being no assault now, they...
Just before you've shown us this before, but I just like to ask you a question about it. If you look at paragraph 46 of the decision, the PSC says, given the MPP ruled it would not take into account the veracity of Mr. Grant's statement, the only evidence it had available to it to make a determination as to whether the appellant struck Mr. Grant twice in the head was the recording itself and the appellant's evidence. Yes. Indeed, as referenced above, Mr. Dunch, the chair, that's presumably of the MPP,
yes,
noted that after reviewing the recording for a substantial period of time, the MPP did not see the appellant striking Mr. Grant. Mr. P.C. McNabb also testified the recording did not definitely show the ASP baton came into contact with Mr. Grant. Now, I quite appreciate that that finding isn't challenged, but if you look at the record of appeal, page 110, where we can find the decision of the misconduct proceedings panel, at page 110 of the record appeal, and at page 14 of the decision, at subparagraph H, it records PC Pereira is then seen to administer 2 rapid blows to the head region of Mr. Grant, one with the ASP in closed mode, followed with one with the ASP extended in open mode. The first blow can clearly be seen to show the bottom of PC Pereira's right hand come into contact with the top of Mr. Grant's head. PC Pereira's left hand is seen palm facing towards him and has the appearance of cupping or holding back the side of Mr. Grant's head, and then it refers 4 lines down. Further examination of the video frame by frame revealed a distinctive shadow underneath to Mr. Grant immediately prior to the second blow that was consistent with PC Pereira's right hand and arm coming back so as to deliver an ASP strike. I'm slightly puzzled as to how it comes about that the MCC records that the chair of the PSC records that the chair of the panel noted after reviewing the recording for a substantial period of time that it didn't see the appellant striking Mr. Grant, when it's in its decision at subparagraph H on page 14, it says precisely the opposite. I mean, maybe we don't need to resolve it, but it is very curious.
Yes.
Well, I don't want to distract you from where you're going, but I raised it because it did seem to me very curious.
Yes, I'll get back to you on that.
Yeah, okay, that's fine.
I'll have a look at it. So paragraphs 24 to 47 deal with the assault, and at the end of 47 they've come to the conclusion that it was unreasonable to find him guilty of assault and has reversed that finding. Then they go on to look at was the MPP's finding that the appellant willfully and intentionally turned his body camera off unreasonable, and they go through this very carefully and with a fine-tooth comb to look at what the MPP found and considered and heard by way of evidence, and eventually came to a conclusion that they couldn't find either him saying cameras off or the fact that he gave an implausible account unreasonable, or that those findings unreasonable. However, in their decision, in their judgment, they do raise a number of different things that in my submission are critical in them coming to the conclusion eventually that although they didn't find those that the MPP's findings in those regard unreasonable, there were mitigating factors to take into account when they eventually go on to consider the appropriate sanction.
Can we just look at, can you take us to where the PSC recorded it?
Paragraph 48, the MPP rejected the appellant's explanation that he was not advising PC Bowden to turn his camera off, but rather instructing him to turn his camera on, and he did not intentionally switch his camera off.
You can take us to what the PSC said, which I think is 51. The panel found that the appellant had willfully turned his camera off. The PSC cannot say this finding was unreasonable in the circumstances.
Yes, and that's a bit overall that is what they found. But in their paragraphs 48 to 52, which is only 4 paragraphs, they raise a number of things which provide mitigating factors, notwithstanding their final determination that there was no unreasonableness in the MPP finding that he had said cameras off and that he had given an implausible account. Namely, they talk about this. They talk about whether or not having a body cam on at all is required by the police, And
Where do they talk about that?
so the
Paragraph
MPP,
50.
the MPP rejected the appellant's explanation that he was not advised. Okay, I've read that. In its findings, the MPP dismissed the appellant's account as implausible. The relevant part of the judgment relating to the turning off the body cam is found at paragraph 14G of the MPP's decision. Having heard the appellant and considered his version of events, the MPP rejected the camera's evidence, the appellant's evidence, and made a finding that the appellant intentionally and willfully turned off the camera. It is noted, I've underlined this, it's noted that PC Bowden's camera was not on during the incident, and he faced no criticism in that regard. The matter was considered during PC McNabb's testimony when it was discussed that when PC Bowden alighted out of his car, PC Bowden did not have his camera on. PC McNabb, who's the expert in body camera equipment for the police, said that in these circumstances, there was no evidence of breach of operational standards when PC Bowden failed to turn his camera on. So the MPP is, sorry, the PSC is
reciting what the panel found. So
Yeah.
I'm more interested in what the PSC said.
Well, the PSC is looking at all of these factors and saying, well, although he was found guilty of gross misconduct for assault, for switching his camera off, and then for giving an implausible account, we've gotten rid of the assault now, and we're focusing on the fact that he switched his camera off.
51.
Yes, and
giving an implausible account, 52.
yes, and when you're looking at whether or not switching his camera off is a breach of operational standards, the PSC is putting it into context by considering, for instance, whether PC Bowden was criticized for not having his camera on.
Not turning it on is actually rather different than having it on and turning it off, isn't it?
Well, it is different, and that is why Bowden was acquitted of all charges and carries on working for the police service, and why the appellant is where he is today.
Yeah.
But the PSC, in considering what the appropriate sanction is, when they have now whittled the gross misconduct down to a finding that he had his camera off, and we'll leave the implausible account to one side for a moment. They're looking at different factors, and this is one of them. They go on to then quote from the evidence given before the MPP. The chair, assuming it wasn't on PC Bowden's camera, whilst I think you were saying what you were saying, whilst it would have been preferable if it had been turned on, you are not surprised, and it's not contrary to operational standards that it wasn't. That's a question to McNabb. That's correct. Acting Commissioner Sean Lament, one of the members of the MPP, so there was Dunch as the chair, Sean Lament was one of the other members, and then there was a layperson, Mr. Soares. I am working the new policy. It's a real area of new development. Certainly the public expectation now is that body cameras will be on for every interaction. The culture of what it was to now has completely shifted, but it's not a requirement to have the body camera on. Paragraph 50, the exchange above indicates that it was not against operational standards at the time of the incident to require the body camera to be turned on. In the circumstances of a chase, where an officer may not have the time or the wherewithal to turn it on during the course of a pursuit, this was not contrary to operational standards. So that's the situation with Bowden.
But, I mean, you're ignoring the fact that there's a material difference between failing to turn a body camera on and having it on, turning it off, which the PSC understood. At the last sentence of 52 was, quote, in order to shield himself from criticism and potential misconduct charges.
Yes. With respect, I'm not ignoring it. The point I'm trying to make is not so much about the, well, I can't ignore it because it's right there. What I'm trying to show is that the PSC, in making its determination, reversing findings and varying the sanction, particularly right now looking at why and whether they were entitled to vary the sanction in the way that they did. They are laying out their reasons for doing so as per Ruckin, and that
Well, it would be, you're entitled to say, and they were entitled to conclude, that it would be worse if he was bound to have it on and had it on and turned it off. But if the position is that whether he was bound to have it on or not, he had it on and did in fact turn it off, it's difficult to see what other reason there can be for turning it off than that it might record something unlawful that he was about to do.
Well, that goes to the nub of my ground 3, which was that the judge in the judicial review erred in law when she said it was implicit in him turning his camera off that he was covering something up.
Well, what else could he have been doing? What else can he have been doing?
Well,
why do you need to turn it off otherwise?
There was never, his position is he never admitted to turning the camera off. He fell over after
no, but there's a finding, and haven't we got to accept that finding?
Yes, we can accept that finding. What I'm trying to argue is that the PSC put their decision together very carefully and in detail, and they were entitled to do that in the way that they did. They took into account the fact that whilst it's still a finding of gross misconduct as per paragraph 52, well, that's the next bit. Paragraph 51, the MPP found that the appellant had willfully turned his camera off. The PSC cannot say this finding was unreasonable in the circumstances, but what they have said prior to that conclusion at paragraph 51 is that they consider that against the backdrop that it was not a requirement to have it on.
Yeah, well, let's consider it against that backdrop. If as a fact, and that's the fact we are stuck with because the original panel found it and the Public Service Commission didn't think there's anything unreasonable in the finding. If the fact is that he willfully, note the word, turned it off, why on earth can he have done so?
Well, in my submission, it's a step too far of the judge in the judicial review to come to the conclusion that he willfully and dishonestly turned off his body cam.
Which page or paragraph of the ruling?
Sorry, I'm just reading my ground of appeal 3, which is basically a quote from the Supreme Court judgment. However, the PSC's acceptance that PC Pereira willfully and dishonestly turned off his body cam was implicit, that they accepted that he did so to prevent access to any evidence of video footage of the events which transpired after he turned off the body cam. And in my submission, once the finding of assault was reversed, it changes things considerably because the gravamen of the allegations, well, everything flowed from the assault. And if there was no assault, then although it may still be argued that he willfully turned his camera off because he didn't want anyone to see what was happening, we can't say that it was because he was trying to cover up an assault. Because
well, just a moment. If there was no assault recorded on the camera before it was turned off, one can say that, well, whilst the camera was on, it didn't show any assault. But that begs the question as to what happened after the camera was turned off. You said earlier, if there was no assault, what was it that he was hiding? To which the answer might be whatever he was going to do after he turned the camera off.
Perhaps, but the PSC in my submission go through that, deal with that very carefully when they look at all of the evidence, including the fact that the complainant didn't make a complaint at the time. In fact, didn't make
but you're not dealing with the point with respect. And the PSC did not change the panel's finding in relation to how to categorize the appellant's action in turning off his body camera. And when it came to the judgment at paragraph 76, which is page 57 of the record, the PSC's acceptance that PC Pereira willfully and dishonestly turned off his body cam was implicit, that they accepted that he did so to prevent access to any evidence of video footage of the events which transpired after he turned off the body cam. I think my Lord President's point, such conduct is the very antithesis of what is expected of a police officer performing his duties honestly and with integrity. And she carried on, conduct falls in the upper category of such breach.
But in my submission, that's purely speculative. And it creates a very different picture. It creates a different picture that the PSC were entitled to consider when deciding whether the sanction of dismissal without notice was still appropriate.
But you're going to the sanction as opposed to the finding. And the PSC accepted the panel's finding and also said giving an inaccurate or implausible account in order to shield himself from criticism and potential misconduct charges was, in the PSC's opinion, gross misconduct. So there you have it.
Yes, but in light of the fact that there was no operational requirement to have his camera on in the first place, and then going on.
That's not helpful, Ms. Greening, because we've already talked about the difference between failing to turn your camera on and having it on and turning it off. And the PSC was obviously alive to the very point that my Lord President raised and the manner in which the judge dealt with it, as to having it on. Why did PC Pereira turn it off? And the obvious inference is so that it wouldn't record the events which might follow.
And there are two questions that might be said to arise. A, why did he willfully turn it off? And B, why did he fib about what he was doing by saying that what he was trying to do was to ensure that Mr. Bowden, PC Bowden, had his camera on? If in fact he didn't intend turning off his camera to have the effect that it avoided detection on his part, it was nothing of the kind. Why did he make up the story about what he was doing?
Well, the PSC addressed that when they talk about his implausible account by saying that he is placed in a very difficult position. That position being that a member of the public has made a false allegation of assault against him, and that he is, up against trying to defend himself and fight for his life or his career.
So it's acceptable in those circumstances to tell a black lie, is it?
Well, it's certainly not. But what I'm trying to focus on is whether or not the PSC were entitled to make the variation in sanction that they did, and whether.
But the starting point of the sanction is what the PSC found in relation to the offence, and what they found that between paragraphs 51 and 53 is that those two matters, willfully turning his camera off, PSC cannot say that the panel's finding was unreasonable. And then bottom of 52, giving the inaccurate or implausible account, they find to have been gross misconduct. And they summarize it at 53. They've reversed the finding of the assault but have not interfered with the panel's finding that the appellant willfully turned off his body camera and gave an account that was not plausible. And they then go on to consider the appropriate sanction.
Yes. So whilst they still find that the appellant is guilty of gross misconduct for 2 out of the 3 reasons that were before the MPP, they then go on to consider in the context of any in the context of what is required of them by the law, by the case law, and by the guidance notes, to decide what the most appropriate sanction is.
Right.
And so they go on and do that, notwithstanding their findings that he's guilty of gross misconduct in 2 out of the 3, and that one of those findings has been reversed.
Ms. Greenie, I'm sorry to go back to fundamentals, but it's still not clear to me whether you are accepting the finding of gross misconduct.
Yes, I am accepting them. Yes, the PSC has made it. I think the point that I'm trying to make, and perhaps this is why we're at cross wires, is not so much getting bogged down in all of the issues, but the main point to make is that the PSC were seized of the matter and entitled to make the decision that they did, that they put they put all of their considerations carefully and clearly in a 22-page judgment, and gave us a pathway in which to walk down to see how they came to the decision that they did. And that was what was required of them, and what they did was proper. That is the argument that I'm making, that I'm making today before this court in relation to whether or not her ladyship, who was seized of the judicial review, was entitled to intervene, which I say she was not. Whether or not we like the idea that whether or not we agree with the PSC's final decision to vary the sanction from dismissal to a final written warning is not the issue. And getting bogged down in all of the details is not the issue. The question is, has the PSC followed the law, which we say it did, and have they come to a decision with reasons that is in keeping with the law as per Ruckin and not perverse? And I'm arguing that they are within the parameters that they are entitled to be in when they came to their decisions. So,
right, wasn't the difference between your submission and what the judge accepted the issue of operational dishonesty? You weren't prepared to accept that the matters that we've just been debating, where the PSC found that the appellant had turned off his body camera and had given an implausible reason for having done so. You said it wasn't an example of operational dishonesty. Is that right?
well, I didn't say that. I accept that it is. I accept that it is a breach. I accept that it is an example of operational dishonesty, because my client was on duty and acting as a police officer when all of this happened. What I am saying is that the PSC is simply pointing out that at that time, it was not a breach of operational standards to have his camera on or off.
Oh, come on, Miss Greening. We've gone through the difference between failing to turn it on and having it on, turning it off. So they're really very different. And it is the latter situation that pertained in the appellant's case.
Yes, and I think that the PSC accept that as well, because at the end of the day,
Well, exactly.
at the end of the day, they agree that the finding was not unreasonable. I am not saying that Salter is not applicable, in that Salter is the leading case that deals with operational dishonesty in these sorts of cases. What I am saying is that Salter is not absolute, that it's accepted by all of these cases, that there's a very small residual category in which people are not police officers are not dismissed, and that the PSC have laid out clearly and carefully and in detail why they have decided that this case fits into that very small residual category, looking at all of the things that they're required to look at, maintaining public confidence and reputation of the police service, looking at the harm, looking at the aggravating and mitigating factors, and looking at at his record to a limited degree. And having looked at all of those things, including the fact that initially he was dismissed without notice for 3 things: assault, the camera being off or being switched off, and his implausible account. He's now
Facing only 2 and 3.
Yes, he's now being found guilty of only 2. That there are certain things to consider in relation to both of them. For instance, that it technically is not a breach of operational standards, although I'm not going to labor that point anymore because it will annoy everyone. And that there may have been, or maybe to consider the fact that the appellant was up against a difficult situation when he gave what was coined an implausible account when he was tasked with this allegation.
Where do we find that the PSC understood that it was dealing with a test of small residual category?
Yes, that's a very good question, my lord. The PSC, and this was dealt with when we were before Her Ladyship at the Judicial Review. The PSC never mentioned or referred to the case of Salter, or the test in Salter, and they're not required to do so. But what they do is, when we get to paragraph 50, paragraphs 24 to 47 deal with the assault, and we've dealt with that. 48 to 52 deal with the body camera and his implausible account, and we've dealt with that. So they're systematically going through everything. At 53, they start talking about the disciplinary action, and they make it very clear in my submission, and I'm sure the respondent will disagree, but they make it very clear that they are aware and live to the issues and requirements that they must take into account. So they summarize what their situation, what their findings are at paragraph 53. At paragraph 54, they say, in considering whether the disciplinary action handed down by the MPP was unreasonable, the PSC reminds itself that the purpose of police misconduct regime is to, 1, maintain public confidence in and the reputation of the police service; 2, uphold high standards in policing and deter misconduct; and 3, protect the public. So at the very beginning of their section headed disciplinary action, they're reminding themselves, and they're putting in writing in their judgment what the most important things to consider are. So it's not as if they've decided to vary it to a final written warning without regard to the most important things they need to be reminded of. They reminded themselves of it, and they've put it right at the top. In determining the appropriate sanction, the PSC must assess the seriousness, and that word seriousness is a key word when looking at the guidance on outcomes in police misconduct proceedings. The first thing you have to look at is seriousness of the conduct, while keeping in mind the purpose of imposing sanctions as outlined above in paragraph 54, the maintaining public confidence and everything, and then choose the sanction which most appropriately fulfills that purpose. So they've done what was required of them, and they've laid out and they've put in writing in their judgment what they need to look at next. So they're looking at the seriousness. The police.
It starts to go awry in paragraph 57, doesn't it? Where what the PSC are looking at and considering important is the lack of an operational requirement to have the camera on, and the comparison between your client and PC Bowden.
Well, in my submission, that is them looking at what I am putting under the category of mitigating circumstances. In considering so they're now quoting the Bermuda Police Service guidance, misconduct guidance notes. In considering the question of outcome, the person conducting the meeting will need to take into account any previous written warnings imposed that were live at the time, any aggravating or mitigating factors, and have regard to the police officer's record of service. So then they're going to go through that. He's got no previous written warnings, so they don't have to deal with that. And 57, they're now presumably going through the next bit, which is any aggravating or mitigating factors.
The problem, or the potential problem, is that they address matters on what they described as a classic plea and mitigation approach, whereas it is said to be the law that the default position for something of this kind, save in very exceptional circumstances, is dismissal. And if one looks at the way in which they analyze the position, they don't refer to the default position, and they don't refer to only to be departed from in very exceptional circumstances. So the fact that they talked about things that were relevant for mitigation could be said to ignore the basic approach which the law says should be adopted in cases of this kind.
I don't think the PSC can be criticised for not explicitly saying that the starting point is dismissal, because they're looking at the MP.
Why not? If that well, just a second. You say they can't be criticised. Yeah, I quite agree. They don't need to refer to a single case. But if the starting point, save in exceptional circumstances, is dismissal, and they make no reference to that being the starting point, hasn't something gone wrong?
Well, just to finish my my thought, the starting point for them is dismissal, because they're looking at the MPP's decision to dismiss him.
Yes, but they haven't looked at dismissal in terms of operational dishonesty.
Well, in my submission, he has been dismissed, and so that's where they are. That's where they're. So
No. That's simply what had happened historically. At this stage, they are deciding what penalty they should impose in the light of the conclusion that they have reached. And it's necessary, or it's said to be necessary for those points, for those purposes, to recognize that the starting point of your thoughts about what to do is that it's dismissal except in exceptional circumstances. It's not relevant to say, oh, but he's already been dismissed. Their question is as to whether he should be dismissed.
Well, it could be argued that they don't. It's obvious that the question is, should he be dismissed? Because that's what they're looking at, the sanction that has been imposed by the MPP.
They changed it. They set aside the dismissal.
Yes, they did.
And the question is whether they should have set aside the dismissal, bearing in mind that the law requires that in cases of operational dishonesty, it will almost invariably call for dismissal, save in exceptional circumstances.
But in paragraphs 57 to 63, they then lay out their reasons from departing from that sanction of dismissal.
Well, with respect, nowhere do they actually say that dismissal is the starting point in offences of this sort. I mean, yes, we know that dismissal was what the panel had ordered, but they didn't look at the sanction of dismissal in the context of operational dishonesty.
I agree that they haven't laid that out. But my argument is that they don't need to lay it out because it's obvious that the starting point for them is dismissal because he's been dismissed. But I suppose those are two different things. The fact
Were
that
there submissions made to the Public Service Commission by people representing the police constables as to, and indeed on behalf of the Commissioner of Police, as to what they should do in relation to sanction?
me, yes. In what the final ground of appeal was that his sanction of dismissal should be overturned. Or was that?
Well, I follow, but I mean, did anybody draw their attention to the cases that the learned judge had her attention drawn to?
No.
No.
Not from my part. Not from my part. I can't recall right now what happened in relation to the respondent submissions, but not from me.
Right. Okay.
So, I mean, just to get to the end of the Public Service Commission's decision,
Yes.
they lay out, they look very carefully and say, in assessing the misconduct, the appellant was clearly culpable in denying he had requested Bowden to turn his camera off with an explanation that was found to be inaccurate. Honesty and integrity are fundamental requirements for a police officer, and it is imperative that the public have confidence in the Bermuda Police Service. And that show, although His Lordship Kay is saying that they go awry at this point, in my submission, it shows that they are live to all of the issues, and notwithstanding being live to all of those issues, they still decide that because of the findings that they have reversed and the different mitigating factors that they have applied to this case, the sanction of dismissal should be varied. It seems that it would be different, perhaps looking at a different way. It would be different if the sanction of dismissal was varied to one of a final written warning, but the PSC had not shown or demonstrated in its decision that it was live to all of these issues, all of them. And notwithstanding the fact that they find what he has done very serious and amounting to gross misconduct, they're still applying mitigatory circumstances to the situation. Not least.
Can I just be clear about one thing? You were asked by Justice Kay whether or not you accepted that there was gross misconduct, to which you said yes. Is that an acceptance that there was gross misconduct under both headings? A, turning the camera off, and B, telling untruths about it?
Yes, I don't think I can avoid that. I mean,
Right.
I never questioned that, because the PSC has made it clear that they find him guilty of gross misconduct.
Just a second. You may well be right about that, but the reason I'm asking this question is that if you go to their decision, paragraph 53, they say the MPP found that the appellant had willfully turned his camera off. The PSC cannot say this finding was unreasonable.
Yes.
And then they say that also the explanation was implausible.
Yes.
And then in the last sentence, they say giving an inaccurate or implausible account in order to shield himself from criticism and potential misconduct charges was, in the PSC's opinion, gross misconduct. So they actually use the phrase gross misconduct specifically in relation to the account of what he said he was doing. They don't in terms use it in relation to item 1, which is willfully turning the camera off in the first place. I mean, maybe there's no distinction to be made between them, but I just didn't want there to be any misunderstanding.
My understanding of it was that he had still been found guilty of gross misconduct in relation to the findings that were not reversed.
Right.
but that there were, as I said before, certain mitigatory factors and circumstances that applied particularly to the requirement to have his camera on and off, and also to some extent the fact that he was in a difficult position, and also they acknowledge the fact that he is in a situation, in a real life high stress situation, where he is dealing with the apprehension of a member of the public who shows scant regard to the public users of the road, places members of the public at serious risk, at injury or worse. The appellant, in carrying out his duties, placed himself at great personal risk during the pursuit of Mr. Grant, who was subsequently found to be in possession of a knife, something that the appellant had a reasonable belief to be the case at the time. And, you know, in some respects, one may argue that given the context in which all of these things unfolded and these things took place, the gross misconduct that this appellant was found guilty of could be lower down on the scale than even Ruckin, who is simply just trying to protect his own personal reputation. This is an appellant who's in a high stress situation, doing the best he can to carry out his duties, and that is something that the PSC take into regard, and as well as the fact that he's a
Rudkin wasn't trying to preserve his own reputation. He was trying to preserve the reputation of another police officer.
Well, one of the things that
So that's Salter, I think.
yeah, so that's Salter.
Is it?
Salter is the one where he asked
Yes. I'm sorry. Yes, I got.
Salter
wrong
asked his
around.
subordinate to hide the.
No, my mistake.
The aggravating feature in Salter, in my submission, or was accepted, I think, is that not only did he do it, but he also ordered his subordinate to do something that was improper. And in Ruckin, although he was ashamed and trying to cover up what was going on with him in his personal life, it upset the panel that he then gave once it all came out in the open what was really going on. He said that he was trying to protect his children from knowing what was going on. They didn't buy that at all, and they got even more annoyed, and that was an aggravating feature, that he should try to not only cover up what had happened in the first place, that he didn't do what the police encouraged members of the public to do, which is report an assault, particularly when the injuries were so severe. But then he also tried to cover up the reason why he had lied, being that he was trying to protect his children as opposed to his own reputation within the force. And notwithstanding all of that, he was still issued a final written warning, and the court did not interfere with that because, and going back to Ruckin, because I don't want to lose sight of the main point that I'm making here. Going back to Ruckin at paragraph 117, furthermore, I do not accept that the decisions of the Police Appeals Tribunal as to liability or sanction were themselves irrational or otherwise unlawful. It cannot, and that's in relation to varying the sanction from dismissal to a final written warning in those circumstances of him lying. It cannot be disputed that the decision which it reached was possibly less harsh than many would have expected, but it is not for this court to substitute its decision for the decision of the Police Appeals Tribunal, which was properly seized of the case, unless, to quote from Holyrood and Williams, the Police Appeals Tribunal reached a conclusion which was so far outside the range of decisions legitimately open to it to render it unlawful. So the question for this court is, has the PSC in this case reached a decision, reached a conclusion which is so far outside the range of decisions legitimately open to it as to render it unlawful? And my answer to that question is no, because one of the options that the PSC had pursuant to the relevant provision in the statute, is to vary the finding of dismissal to one of a final written warning. And they laid out their decisions for doing so by taking us through the important principles to consider and adhere to, the seriousness of the case, the harm caused, the aggravating features, which they do identify as being his implausible account is an aggravating feature, the mitigating features, which they've laid out, and then they've come to and then his record and the context in which all of this has happened, which is that he's, in a high speed, high stress situation with his colleague and a member of the public in possession of a knife. So in some circles, my client would be praised for the apprehension of Mr. Grant in those circumstances. And the PSC has taken all of that into account and has come to the conclusion that whereas the MPP decided that gross misconduct under the 3 findings they found must result in dismissal, they chose to vary it. And as per Ruckin, which is a case that follows Salter and Williams, refers to Salter and Williams and others, and comes to the conclusion that in a very similar set of circumstances, it is not proper for a court to interfere when the appeals tribunal have, and the difference also in the Ruckin case is that, as I said earlier, there are many references to the decision not being particularly detailed. It says, I do not overlook Mr. Apthorpe's argument as to the inadequacy of the judgment and its alleged failure to explain how the PAT came to its decision. I readily accept, sorry, I'm reading paragraph 118. I readily accept that the judgment could have been fuller, but I do not accept that it is not possible to understand how the PAT came to its decision, both in relation to liability and sanction. It seems to me, it should say, to be clear that it undertook the balancing exercise in relation to issues surrounding privacy. It may have come to a decision in favor of privacy, which others may have not reached, but that does not make the decision irrational in the sense that it was outside those which could have been legitimately reached. And I think just the paragraphs that follow basically just reiterate this test, which is this conclusion may be one which others would not reach, but it does not make it unreasonable or irrational. And it's for this reason that I have brought this matter to the Court of Appeal, and I hope that I've been succinct and clear in arguing why her ladyship, who was seized of the judicial review, erred in law when she came to the decision that the PSC were not entitled to vary the sanction in the way that it did. I do not intend to pursue the ground of appeal 5, which deals with the PSC failing to instruct independent counsel. So you will not have to hear arguments in relation to that. And I believe that in relation to grounds 1 to 4, I have covered everything.
I think you have, subject to any questions that any of my colleagues may have.
No, thank you.
I reserve the right to reply, though, if there's anything that comes up.
Yes, you would have that in any event.
Thank you.
We will take a 10-minute break. Please don't go away for long, but we will have a 10-minute break ourselves.
Thank you.
Mr. Taylor and Ms. Greening, well, you've done what I was going to tell you to do, so never mind. then move.
Yes, my lord, someone in the room notified me that maybe I should put my jacket on.
Yes, I think
Address
that,
my
that would be
lords
wise.
and-
Yeah, I think that would be
Yes.
wise. Mr. Taylor, we've heard Miss Greening's admirable submissions, and we have read the written submissions in advance of both sides, including,
Yes,
of course, yours.
Yes, my lord.
Unless there's anything that you wish specifically to draw our attention, we do not think that we need to trouble you further.
My lord, I'm most grateful, and I'm sure you have the. I will make one point if I may, because it's a new case that was submitted late in the day. No criticism to my learned friend. It's the Cleveland Constabulary and Rukin case, my lord. The only thing I wish to say about that case, and I believe my Lord President Clark, I believe that you are right on top of it when you asked the question of my learned friend about gross misconduct. You will appreciate, and my lords will appreciate, that the Rukin case is very much different, because what took place in that case, and it's in paragraph 2 of the summary, was that the PAT viewed the conduct in question as not gross misconduct, but rather simple misconduct, if I can put it that way. And of course, what that does, in my respectful submission, is that then opens, shall we say, we talked about earlier about the gates are opening when you find something to be unreasonable. The gates are open much wider. The difficulty here, of course, is in this present case, is there are accepted findings that cannot be touched by the PSC, that this was gross misconduct, which was dishonest in an operational context. And when we are there, quite rightly, the almost inevitable result must be dismissal, unless there are some, that small residual sliver of exceptional cases where there are exceptional circumstances, which we say this isn't one. Madam President, thank you.
Yes,
I don't wish to trouble my lords any further.
right. Ms. Greening, is there anything you want to say in response to those few sentences?
Muted.
You're muted.
Yeah,
I took that to mean
nothing further. I hope that the court will read through the cases that I included in my bundle of authorities carefully, including the Vogler and Flint cases, where gross misconduct was found and the sanction was less than dismissal.
right. Okay. Thank you. Well, we will give judgment in due course. We're grateful to both sides for their helpful submissions.
Thank you very
We will
much.
adjourn.
Thank you, my lords.
All right, thank you. If I can ask the court to retire to the breakout room and everyone else can disconnect from the call.